Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Welcome back to FDA Imports, cross-border compliance with attorney Benjamin L. England. Benjamin is a founder of FDAImports.com and a former FDA regulatory counsel who helps businesses navigate the intersection of FDA oversight, customs enforcement, and international trade. I'm Evan Mack, and today we're talking about what happens after your product clears the border when post-market inspections, complaints, or recalls bring FDA attention back to your doorstep. Benjamin, sir, welcome back.
Oh, great. Good to see you, Evan. Thanks so much.
Awesome. We're going to get into post-market problems when the FDA comes knocking at your door, if your product is already on the shelves. Today's focus is about FDA investigations after importation, but quickly, Customs also has questions it might ask after shipments are imported. What does that process look like before we get into the weeds with the FDA?
Yeah, great. So remember, when cargo is coming in, there's a lot of attention when it's crossing the border. It's going through the import process, the entry process. There's a lot of attention. The government is looking. Now, the government's not looking at most things because they can't, right? There's just too much cargo. However, it is a bottleneck, first of all, right? It's a spot where the government officials are and the cargo is going by, right? You don't get that when you're shipping from Atlanta to Florida. Right, there's no customs officer or no FDA officer at the Florida-Georgia border. There is one in Miami and there's one in Atlanta, right? So they have opportunities and they take those opportunities. That's where most of the focus is happening with imported cargo is at the border. But once it goes through, generally, this is a customs issue. Any import is subject to later questioning by customs. In fact, when you import cargo, your cargo is going to go to a warehouse under a bond that is designed to give you custody of the cargo and customs power to get it back, right? And the power is basically the bond, the money that has been posted usually by a surety, like the insurance company, the same way bail bonds works, in criminal cases. But so customs has constructive custody of the cargo. And there's a period of time when customs and other agencies are figuring out what they're going to do. That's that initial interaction with the cargo and the government, and then customs releases it. After customs releases the cargo, customs can always come back and ask questions about duty, the tariffs that would apply. That's your harmonized tariff schedule, your HTS classification. They can ask questions about origin, which matter. They matter for things like forced labor. They matter for things like whether or not trade agreements apply to the cargo and you're entitled to a duty of 0 rather than a duty of 35%. Big difference. And it's money and the government cares. So there's always the opportunity for the government to come back and ask questions. And they can go back 7 years into your import history in order to determine whether or not they've got a problem, right? So if they show up, it's an issue on imported cargo. You have to have records for customs that are separate from the FDA. So yeah, it's and the FDA was obviously a much more detailed question. We're talking about recall events and those kinds of events. But for imports, I wanted you to realize that there's this thing that you can't ignore. I mean, customs they're carrying the stick. Everybody else is walking around inspecting stuff, and customs is carrying the stick.
So let's get into the FDA specifically with them. A lot of importers assume that once their shipment clears customs, the compliance process is completely finished. Why is that not always the case?
Yeah, well, it depends upon whether or not the food was safe and the pharmaceuticals were safe and the medical devices were properly labeled and weren't making claims they weren't supposed to make. Right? It depends upon the compliance of the product and the experience of that product in the actual marketplace when it's in the hands of the consumer. And if there's a problem that arises, the government's job is to obviously do investigations. FDA's responsibility is to evaluate that. Now, at the border, the FDA's jurisdiction is very, very broad and very, very high, and it doesn't need a whole lot of evidence in order to take action on imported cargo. It just needs the appearance of a violation. I mean, think about that, right? They don't have to prove that it's violative, that it actually violates the law. They have to prove that it looks like it to me, right? That's the government's position, and not very much. But once it gets through the border, FDA's standard goes up, right? It has to meet a higher burden of proof in order to take regulatory or legal action. So it uses a lot of regulatory tools, things like recalls and investigations. So if there's a contamination event, if there's some sort of an outbreak, if it turns out that someone tests your product and finds that it's contaminated and it makes its way to the FDA, then the FDA will give you a call, or the FDA will show up, or they may even conduct their investigation without talking to you first and then come talk to you. But it's usually because there's a problem with the product.
Well, what kind of post-market issues tend to trigger this FDA scrutiny? Is it consumer complaints or adverse event reports, or maybe something else entirely?
Yeah. So adverse event reports are actually, in some cases, the industry is required to make them, right? So if I get a report of an adverse event, there are requirements in all of the FDA regulated spaces at various standards, with various standards like levels of risk or harm or those kinds of things, the kind of complaint, the number of complaints. There are reportability events that the regulations define. The complainant, that's the consumer, or sometimes it's the hospital, right, who actually had a patient come in and had illness, and they report it. That's voluntary, right? So the government only gets whatever they get when it comes from the complaints. There's other kinds of complaints. There's trade complaints, and those complaints are particularly nasty, right? Those are the complaints where you and I are competitors, Evan, and I think you're doing something wrong because one of your employees now works for me and told me that you were cutting corners. And so I make a trade complaint to the Food and Drug Administration, which is an anonymous complaint, and then FDA comes to investigate you, right? It can come those many different ways. And of course, the other way it can happen is that there's an event that the government, usually with the CDC and FDA together, they start identifying, wait, we have multiple cases of these, and then they start looking at the test results to see if they're related, right? Scientifically, are they related? Do we have the same species of microbiology, of bacteria? Is it the same gene? Is it not genus? Is it the same oh no, I just lost the word. I'm a microbiologist for the FDA and I can't think of the word. But is it can it be identified to a particular group within that species? And can they make matches? And in other words, they say, oh, we have a problem here, right? Think of it like homicide detectives deciding if they have a serial killer or not, right? It's the same kind of thing, right? Except for they're using the scientific data. So those are the ways it can come, that it can come to the FDA, and then the result is the FDA comes to you.
How does this FDA typically approach these situations? Investigators do they show up unannounced? Is it written notice? Is it is it like the movies?
Yeah. Oh yeah, it's unannounced. Or FDA's almost everything FDA does is unannounced. And that which we want it to be that way. Industry wants it to be that way. They don't like it, but it's important because you don't want to be you don't want to have you don't want to be cramming for the test, right? You want to actually be doing the work before they show up to do the inspection. So it's unannounced. How they come up depends upon what they think the problem is. FDA has inspection authority and it also has investigation authority. If they give you a notice of inspection, then they're inspecting your facility. Usually in a traceback situation or an adverse event follow-up or consumer complaint evaluation, they're going to come in and they might not issue an inspection report. And if they do, inspection notice. And if that's true, they're still authorized. They still can conduct the investigation. They have investigation authority, but they're not conducting an inspection. And it matters because inspections, if I give a 482, an FDA inspection notice to a firm, which I've done many times when I was at the FDA, if I give a 482 to somebody, that gives me statutory right to see certain documents. And they cannot withhold them. If they do, they're refusing the inspection, which has its own penalties. Now, if I'm coming in to conduct an investigation and I don't issue a 482, I don't get all of that as an inspector. I don't get all that extra power behind me. I'm conducting an investigation, and there are certain records that I can get that are related to the event, right? But it's not like I can't go in and do an inspection of your whole facility. I'm there to do the one thing. But now, if it turns out that they think that you're a criminal, I was at the FDA for 6 years. I carried a gun for the FDA in the Office of Criminal Investigation. So I conducted criminal investigations for FDA and Customs when I was at the agency, and we didn't tell them we were coming, right? So that's a different game. That's a search warrant usually. Maybe it's a field interview, but it will raise the hair on the back of your neck. Particularly the former. But they'll come to you depending upon the risk, the speed with which they come, and the speed with which they expect you to be responsive with documents and with evidence and documentation on manufacturing and where the product went, et cetera, is all going to be dependent upon the degree of risk that the FDA perceives with respect to the event. Right? Is this something that is probably going to be replicated because it probably is consistent across the lot, and we got people in the hospital? They're going to be very, very motivated to get as much documentation as they can, and we would want that. Is it very, very isolated? Does the government think that one of your employees is doing something illegal? That's pretty narrow, right? and yet it's very, very intense. They come unannounced. They come in lots of different, wearing different kinds of suits and carrying different kinds of badges, and they come for different reasons.
How are these, importers or distributors held responsible if the original manufacturer made the mistake? For example, this the formulation change or incorrect label update overseas. How are they held responsible?
Yeah. So let's divide responsibility into two pieces. One is you're like morally, legally, ethically responsible, and the government could bring an enforcement action against you, right? That's a form of responsibility. The other is I shipped the product to you, and it turns out that there's a problem with the product. I am responsible for the product that you got to you, right? And to also the government to do certain things because I'm in the supply chain. Right, they're both responsibility, but they're different kinds of responsibility. Most of the responsibility is in the second one, because usually I'm not usually morally ethical as an importer, morally responsible or legally responsible for failures of the foreign supplier. They are, and the government doesn't want to come inspect me for a food manufacturing problem when I don't manufacture food. Right, it's a waste of their time. But they want to know who the manufacturer is, and they want to know what they might come to me to get evidence or information about the foreign manufacturer. Now, I distribute something to you. The FDA might come to me and say, "Are you going to do the recall?" Okay, that's responsibility that matters, right? Because that's expensive and it's public, depending upon the level of the recall, whether it's a level 1 to class of recall. And that question that goes to how deep in the supply chain I have to go to recall the product. So as an importer, I can definitely be held responsible for the impact of that product in the market, and might be responsible for paying for the cost of getting it back out of the market because I enjoy the luxury of importing product in the United States. Importation is not a right any more than immigration is a right. Like nobody has a right to come into the country, and nobody has a right to import. It's a privilege, and it's governed by statutes. So I get a privilege as an importer, and my clients are all importers. Well, half are importers and half are manufacturers, right? But they all enjoy privileges, but responsibility comes with that.
What's the difference between a voluntary recall and one initiated under this FDA pressure, and how should companies decide which path to take?
Yeah. Well, so there's mandatory recalls, right? And those are mandatory. And then there's voluntary recalls. Those are all the others, right? In deciding which path you're going to go, the statute's going to dictate if it's mandatory. But most recalls are not mandatory. And the reason is because the statute, there's a lot of, FDA regulates about, I'm going to guess, it's probably got to be 40% of the GDP, right? It's massive. Just think about it. Walk into a grocery store, walk into a pharmacy, right? You walk into an airport and walk through the magnetometer. FDA regulates it. I mean, FDA regulates stuff that you wouldn't imagine. They regulate tobacco now, right? They have interest in alcohol. So just think about the sweep of FDA's jurisdiction. So FDA's got a very, very broad jurisdiction. So all of these different products all represent their own level of risk, right? So voluntary recalls, even though like medical devices have mandatory requirements, food products are subject to mandatory recall authority. Pharmaceuticals are not, which might surprise you, right? There is no statute that gives FDA the authority to come to a pharmaceutical company and say, you will recall that lot of pharmaceuticals. Yeah, right. It's just like that shows you the impact of political pressure because of the sweep of the Food and Drug Administration, right? It regulates such a large swath of industry. So most recalls, therefore, are voluntary. Now, the next question is, and you want to cooperate with the FDA without question, right? FDA has a procedure for doing voluntary recalls. That is not regulation. You're not obligated to follow it, but you won't make FDA happy if you don't. But there's times when I tell my clients and I tell FDA, we're not doing that. We don't need to do it. It doesn't apply. It's not a regulation. You can't make me do it. You don't have mandatory recall authority. So look, we're going to work our way through this, but we're not doing that. So there's certain times that you may not follow that policy. But the differences have to do with the class of recall, class 1, class 2, class 3. All right. Class 1 recall, highest level. That's where your mandatory recall authority is. If the violation or the problem with the product, the adulteration or the contamination or the defect with the product is of significant risk that it's likely to cause that exposure to the product is likely to cause a substantial physical impact or death, right? We're talking about stuff that will kill you or put you in the hospital, and maybe you'll recover, but you might have effects that linger for the rest of your life. All right, class 1. Then you get hospitalization, illness, recoverable, death is unlikely. That's your class 2. Then you get the stuff that is probably could make you sick, relatively high risk with of that. That's class 3. And then you get to, it's technically in violation, but it probably won't hurt anybody, right? Right. That's a market withdrawal, right? That's not even a recall. So the level of recall by class is going to dictate how deep you have to go, how much involvement the FDA is going to have, and how much they're going to push you. And if they have mandatory recall authority, they're giving you the chance to do the voluntary. You're going to probably have to do more of what they want because they could make you do it. And the reason FDA doesn't is because the regulatory hurdles are complicated. They've created administrative procedures that makes it difficult for them to execute their own mandatory authority. So most of this is going to be dictated by class of recall and the kind of risks associated with it, and that will then indicate how many people I have to go to, how deep into the supply chain. If I'm an importer and I sell to you and you're a manufacturer who manufactures product that goes to a distributor, that goes to a retail outlet that has its own distribution and finally goes into a shelf and a consumer buys it. Lots of levels, right? How far do I have to go to tell people about the problem? And that's about the class of recall, right? It's about the risk, right, associated with the product. It might be that it's not necessary to go to the consumer, but you want to get the stuff that's not in compliance off the market. So you might go to the distribution level. You might go 2 levels down. As an importer, you can be responsible for the recall, particularly if the manufacturer is not cooperating, right? If the manufacturer decides they're going to wash their hands and walk away, they're probably walking away from the market, and you're going to be stuck doing the recall. Now it's Evans food import company that is issuing a recall for food that caused illness in the states of California, Utah, and Nevada. Right?
That's crazy.
You don't like that because you didn't make it, right?
Yeah, I wouldn't. I wouldn't want my name on
but
that.
You're doing the recall. And if you don't, the government will do public announcement and they'll say Evan imported this food and it caused people to make it sick, and they're going to write it, and you're not going to have any input on what they say. Right. So when you cooperate with them, you get to work with them on the public statements, right? And how it's communicated, and you get to direct the inquiries to you rather than to the FDA. So all those pieces, and it doesn't matter whether you're an importer or what you are, and everybody has that risk.
Wow. So finally, what would be your advice for these importers and brand owners who want to build a compliance system that holds up long after the product hits the market?
Yeah, so always the best thing is to know your suppliers and to have confidence that the product that they're making for you is going to meet your specifications or some industry recognized or government recognized specification that exists for a reason. And so you want to make sure that they're manufacturing it. That means you're gonna do some verification and some auditing. And this is not restricted to food, right? We're talking about cosmetics, pharmaceuticals, medical devices. Now, pharmaceutical medical devices already, there's going to be a lot of auditing involved because there's a lot of auditing in the component and the ingredient manufacturing steps. But foods and cosmetics, not so much. So the importer is going to be looking for evidence that they know what they're doing in the manufacturing side. That's the one thing I would do. The second thing I would do is I would have a recall plan. Like, I don't want to have the government calling me and saying, "Are you going to do a recall?" And you're going to say, I don't know. Do I have to? Wrong question to ask the government, right? Because you don't know what the answer is going to be. And they may show up in your facility and ask you to do it too. They may not give you a call, right? Sometimes they give you an email and say, "Can we talk on the phone?" And that one tells me it's not a class 1, right? Because they're not doing that if it's a class 1. If it's a class 1, they're knocking on the door saying, "Hey, look, we've got this evidence. Here's the lab results. It came from you. We actually documented. Look, the lot number is actually here. I assume you're going to recall this, right?" Right. So like the approach is very, very different. So you don't want to be then deciding, how do I do a recall? You want to know how to do a recall. Now, you may not want to do mock recalls, but you got to at least train your people. You got to at least have you also got to build it into your contracts, for God's sakes, right? If I'm buying food from somebody else and I might be stuck recalling it, I want some recourse for that, right? I want them to agree that if I buy their product and the government comes to me, that they will do the recall. I want their name on the recall. All I did is just implement. Like, I'm just the importer, man. I'm the piano player. Right? Don't shoot me. So you want to try to push that kind of responsibility upstream to your suppliers. Your customers ought to be doing the same thing to you, and that ought to be a signal, right? When Walmart or CVS or Food Lion or whoever, right, is buying from you, and you read that contract and you realize all the stuff that you said you're going to do because you wanted the deal, Well, you better turn around and have someone else doing it for you, right? So the contracts are really, really critical. And you got to know what the risks are, and you have to know how to respond to those risks. You also have to know what your rights are, right? A lot of people will drop into a situation of being cooperative with the government, which people should, you shouldn't be uncooperative, but it doesn't mean you've got to give them everything. You got to get some advice from somebody who knows what the government's allowed to require you to do, and to do the assessment, and who's done recalls. I've done recall events, right? I've followed up these products. Lots of people have done it. So you want somebody who knows what they're doing.
Good stuff, Benjamin. Thank you so much for your time, sir. Informative. Good stuff.
Thank you. Appreciate that very much. Thanks for the time.
That's it for today's episode of FDA Imports Cross-Border Compliance. If your company is facing a post-market inspection, recall, or compliance review, don't wait until it becomes an emergency. Visit FDAImports.com to connect with Ben and his team for that expert guidance. And if you found this discussion helpful, please leave a review, like, subscribe, and share this with someone else that might find it helpful. Thank you so much. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.